34, 83.3 million, 11,780, 90 for numbers, all real, all documented, all sitting in official court records right now, and not one of them changed a single thing. The man those numbers belong to is currently sitting in the Oval Office. That is not an opinion. That is the documented sequence of events. And it is the thread that runs through every single case we are about to examine. Because what this story is really about underneath the indictments, the verdicts, the phone calls, the documents, the checks, and the financial statements is a question that the American legal system has never had to answer before. What happens when the machinery of accountability collides directly with the machinery of power? What happens when the evidence is real, the proceedings are legitimate, and the verdict is unanimous, and none of it is enough? We are going to find out, case by case, document by document, number by number. But first, notice something about the way this story is usually told. Every case gets its own news cycle, its own headlines, its own moment of outrage or dismissal. And then the next case arrives and the previous one fades into background noise, replaced by something newer, something louder, something more immediately urgent. The previous case never disappears entirely. It just stops being the thing everyone is talking about. And in that gap between the headline and the memory, something important gets lost. What nobody's, not the networks, not the newspapers, not the political commentators on either side, is line them all up. Put them next to each other. Look at them together, in sequence as a single body of documented evidence rather than a series of separate controversies. Because when you do that, when you actually look at all of them together, a pattern emerges that is impossible to explain away. In every single case, there was a document, a recording, a signature, a specific number, physical, verifiable, traceable evidence that existed before any prosecutor decided to act, before any grand jury was convened, before any indictment was drafted. Evidence that came from the Trump Organization's own books, from surveillance cameras inside his own property, from a phone call he made himself, from financial statements his own company submitted to banks. And in every single case, without exception, the response to that evidence followed the same script. The document does not mean what it appears to mean. The recording was taken out of context. The signature is routine. The number is subjective. The allegation is a hoax. Same pattern, different evidence, every single time. Keep that in mind as we go through each case, because by the time we reach the end of this video, you will have seen that pattern repeat so many times across so many different types of evidence, in so many different courtrooms and jurisdictions, that coincidence becomes an increasingly difficult argument to make. Before we go any further, there are people in this story who are not abstractions, and they deserve to be recognized before anything else is said. Jean Carroll spent nearly 3 decades carrying an account of what happened to her inside a Manhattan department store, before she decided that silence was no longer something she could afford. Stormy Daniels became shorthand for a political scandal, while the actual human being attached to that name was largely erased by the coverage that claimed to be about her. The election workers in Georgia, ordinary people doing a civic job, received death threats. Because their names appeared in documents connected to a pressure campaign they had absolutely nothing to do with. These people are real, their experiences are documented, and they will be at the center of what follows. If you want to follow cases like this with the depth that mainstream coverage never gives them, click the subscribe button right now and turn on notifications. Here on this channel we look at what was filed in court, what was said under oath, what juries decided, and what the official record actually shows, not what any political side wants you to believe about it. New cases and updates every single week. And leave a comment right now before we go any further, after everything you are about to hear. Do you think any of this should have ended differently? Tell them below. Let's begin with the case that establishes the pattern, not the most dramatic case, not the biggest numbers. The case where the evidence was the simplest, the most physical, and the hardest to dispute. Because the hush money case is not really about $130,000. It was never really about the payment. It is about what happened to the paperwork afterward. And the paperwork is where this entire story lives. October of 2016. Less than 2 weeks before a presidential election that every poll, every analyst, and every political operative on both sides treated as one of the most consequential in a generation. Michael Cohen, Trump's personal self-described figure, wired $130,000 to a lawyer representing a woman named Stormy Daniels. In exchange, Daniels signed a non-disclosure agreement agreeing never to speak publicly about an alleged sexual encounter with Trump that she claimed took place in 2006 at a golf tournament in Lake Tahoe, Nevada. The payment was hidden. The agreement was sealed. The election happened. Trump won. And for 14 months, the silence held. Then the Wall Street Journal reported the payment's existence in January of 2018. The story broke open. And the legal problem that followed was never really about whether the encounter happened or whether the payment was appropriate. The legal problem was about the paperwork, specifically about how Trump reimbursed Cohen afterward. Stop here, because this is the first time in this story that the pattern appears clearly, and it will not be the last. When Trump reimbursed Cohen, the total was not $130,000. It was $420,000, structured as monthly payments of $35,000 over 12 months, padded with bonuses and gross-up payments to cover Cohen's tax liability on the income. And every single one of those payments was recorded in the Trump Organization's internal financial documents as legal expenses, as a retainer for professional services rendered, not as reimbursement of hush money paid to a woman who had signed a non-disclosure agreement, not as a campaign-related expenditure that might trigger reporting requirements. As legal fees for legal work that prosecutors argued and the evidence supported Cohen never actually performed. 34 separate entries in the official books of the Trump Organization. 34 records. Each one describing the same transaction in the same way. The same description used consistently across an entire calendar year. That is not a bookkeeping error by an overworked accountant. That is not an isolated mistake. Prosecutors argued it was a deliberate, sustained pattern of falsification, and the jury agreed. The defense response at trial was exactly what the larger pattern would predict. The documents mean what they say. Cohen is a convicted liar who had already pleaded guilty to multiple federal crimes, including campaign finance violations, tax fraud, and lying to Congress, and therefore had every conceivable motive to shift blame onto his former employer. The payments were a private personal matter unrelated to the campaign, and therefore no underlying crime existed that would elevate the record falsification from a misdemeanor to a felony. The argument in its simplest form, the document does not mean what it appears to mean. But here is what the defense could not explain. Stop for a moment and let this land, because this detail matters more than any argument either side made in that courtroom. The checks were real. Physical checks, signed by Donald Trump personally, made out to Michael Cohen, totaling $420,000 across 12 monthly payments. Those checks were not discovered by investigators. They were not obtained through subpoena or search warrant. They were introduced into evidence because they existed in the Trump Organization's own records. 12 jurors looked at those checks. Trump's own signature was on them. and the internal ledger entries describing those payments as legal fees for a legal retainer were produced not by the prosecution but by the Trump Organization itself, the company's own financial records maintained by its own employees, directly contradicted the company's own defense theory. The jury deliberated for slightly less than 10 hours across 2 days. On May 30th, 2024, the verdict came back on all 34 counts, guilty, unanimous, not a single juror dissented. It was the first criminal conviction of a former president in the history of the United States. Hold that verdict. We will return to what it means at the end of this video, because what happened next is the single most consequential fact in this entire story, and it belongs at the end, not here. The pattern appears again in the financial fraud case. And this time the numbers are not in the hundreds of thousands, they are in the billions. For years, New York Attorney General Letitia James had been investigating the financial statements that Trump and the Trump Organization submitted to banks, insurers, and other financial institutions when seeking loans, negotiating terms, and establishing creditworthiness. Her office alleged that those statements did not reflect reality, not in small ways, not in ways that could be attributed to the natural subjectivity of property valuation or the optimistic projections that are standard practice in real estate negotiations. Her office estimated that in some years, the total inflation across Trump's stated assets reached as high as $3,600,000,000 above their documented actual values. The specific examples that emerged at trial are not abstract accounting disputes. They are documented, specific, and measurable against public records that anyone can check. The triplex apartment at the top of Trump Tower, Trump's primary New York residence and one of the signature properties of his personal brand, was listed in financial statements submitted to lenders as having approximately 30,000 square feet of living space. Stop. Look at that number. 30,000 square feet. The actual square footage of the apartment, according to the New York City Department of Finance's own publicly available property records, was approximately 11,000 square feet. The financial statements submitted to banks listed the apartment at nearly 3 times its documented actual size. Not a rounding difference. Not a matter of measuring methodology. A difference of approximately 19,000 square feet on a document whose entire purpose was to establish the accurate value of the asset. The defense response was entirely consistent with the pattern. Real estate valuation involves judgment. Square footage can be calculated in different ways. The number is a matter of interpretation. The document does not mean what it appears to mean. Mar-a-Lago, the Palm Beach estate that Trump converted into a private club and that became the center of a separate criminal investigation, was valued in financial statements at as much as $739 million. Real estate experts who testified at trial, examining the property against comparable sales and applicable restrictions, placed its actual market value at approximately $75 million. The reason for that dramatic difference was not a matter of opinion or methodology. It was a legal document. Trump had signed deed restrictions permanently prohibiting the property from being used for residential development. He signed those restrictions himself. They are recorded in Palm Beach County's public property records. His own financial statements appear to have been calculated as if those restrictions, which he personally created, did not exist. Judge Arthur Engoron, who presided over the case, ruled in September of 2023, before the trial even began, that fraud had already been established as a matter of law. The question of liability was settled before the first witness took the stand. The trial that followed was conducted solely to determine what the appropriate penalties should be. in February of 2024. After 11 weeks of testimony from 40 witnesses, Engoron ordered Trump and his co-defendants to pay $364 million, with prejudgment interest accumulating at approximately $112,000 per day from the date of the original judgment. The total owed by Trump personally exceeded $450 million within weeks of the ruling. He was also barred from serving as an officer or director of any New York corporation for 3 years. His sons, Eric Trump and Donald Trump Jr., faced 2-year bans. In the written ruling, Engoron described the financial conduct at issue and wrote that the frauds in this case shock the conscience. That phrase appears in an official judicial ruling. It is part of the public record. In August of 2025, an appeals court reviewed the case and issued a split decision. The court upheld the fraud finding in its entirety, meaning the legal conclusion that fraud occurred remains in effect as a matter of established law. But the court voided the financial penalty as excessive, finding that the harm caused, while real, did not justify a judgment approaching $500 million. New York Attorney General James is weighing whether to appeal that reduction to the state's highest court. The fraud stands. The penalty question remains unresolved. Now, we go to the case with the most extraordinary single piece of evidence in this entire story. Not a document that requires expert analysis to interpret. Not a financial statement that needs an accountant to explain. Whole, recorded, released in full, available for anyone to listen to. A phone call in which the sitting president of the United States said something that no amount of context can fully neutralize. January 2nd, 2021. The presidential election had been called 5 weeks earlier. Biden had won Georgia by 11,779 votes. The margin had been confirmed by a machine recount, a hand recount, and a second machine recount. Georgia's Republican Secretary of State, Brett Raffensperger, a man who had voted for Trump and publicly supported him, had certified the results and repeatedly and publicly defended their accuracy against claims of fraud. And, on that afternoon, his phone rang. The President of the United States was calling. The call lasted approximately 1 hour. Raffensperger had his legal counsel on the line. The conversation was recorded, and in the course of that hour, the President told the Secretary of State that he needed to find 11,780 votes, not 11 million, not 11,800, 11,780. Exactly one more than Biden's certified margin of victory in the state. He told Raffensperger that he was taking a big risk by not acting. He made specific claims about fraudulent ballots and manipulated voting machines that Raffensperger and his staff corrected, with specific documented counter-evidence in real time on the recording. And he returned again and again to variations of the same request: find the votes. Stop and let that number sit for a moment, because the mathematics of what was being requested deserve to be understood clearly. The margin was 11,779. The number requested was 11,780. One more than the exact margin needed to flip the state. The precision is not incidental. You do not arrive at 11,780 by accident. That number requires knowing the certified margin and adding 1. The defense response, consistent with the pattern established across every other case, the recording was taken out of context. The president was not asking an official to manufacture votes that did not exist. He was asking for a legitimate investigation into votes he believed had been miscounted. The recording does not mean what it appears to mean. Fulton County District Attorney Fani Willis brought the most expansive indictment in this entire story, charging Trump and 18 co-defendants under Georgia's racketeer-influenced and corrupt organizations statute. a law originally designed to dismantle organized crime networks, with participating in a coordinated criminal conspiracy to overturn the certified results of the presidential election. The indictment covered the phone call, coordinated attempts to submit fraudulent slates of presidential electors in multiple battleground states, a pressure campaign directed at Vice President Mike Pence to refuse certification of the electoral vote count, and a specific operation to access and copy voting system data in Coffee County, Georgia, without authorization. And then the case collapsed, not because a jury heard the evidence and found it insufficient, not because a judge reviewed the indictment and found it legally deficient. It collapsed because of a personal relationship that had nothing to do with the evidence. Willis had hired a lawyer named Nathan Wade as a special prosecutor to lead the case. It later emerged in court filings that Willis and Wade had been in a romantic relationship. The Georgia Court of Appeals disqualified Willis from prosecuting the case in December of 2024. A replacement prosecutor was appointed. That prosecutor declared he was unable to find a willing co-counsel, and in November of 2025 he dropped all charges against all remaining defendants. The case is over. The recording of the phone call remains publicly available. The indictment documents remain in the public record. The case is gone. The federal election interference case brought by special counsel Jack Smith charged Trump on 4 counts in August of 2023. Conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, and conspiracy against rights. The charges described a coordinated multi-part plan to prevent the certification of the Electoral College results on January 6, 2021. The trial was scheduled for March of 2024. In July of 2024, the Supreme Court ruled that former presidents have broad immunity from prosecution for actions taken in their official capacity. The case was remanded to the lower court for further proceedings consistent with that ruling. Trump won the presidential election in November. Special counsel Smith filed a motion to dismiss all charges the day after Thanksgiving, citing the long-standing Department of Justice policy that prohibits the criminal prosecution of a sitting president. The motion was granted. Now, the classified documents. And here the pattern shows up not in a single document, but in approximately 100 documents, stored in locations that no national security expert would consider remotely appropriate. When Trump left the White House in January of 2021, boxes were transported to Mar-a-Lago. The Presidential Records Act, a federal law passed in 1978 in direct response to the Nixon administration, requires that all presidential records be transferred to the National Archives at the conclusion of a president's term. The archives spent months attempting to recover missing records. 15 boxes were voluntarily returned in January of 2022. Inside those boxes, investigators found documents bearing classification markings. The matter was referred to the Department of Justice. A grand jury was convened. A subpoena was issued demanding the return of any remaining classified materials. In June of 2022, a lawyer representing Trump signed a written certification stating that all materials responsive to the subpoena had been returned and that no classified documents remained at Mar-a-Lago. That certification was false. FBI investigators had developed independent information suggesting additional classified documents remained at the property. On August 8, 2022, agents executed a court-authorized search warrant at Mar-a-Lago. They recovered approximately 100 additional classified documents. Some carried classification markings at the highest levels recognized by the United States government, covering information related to nuclear weapons programs and the foreign intelligence. collection capabilities of American intelligence agencies. Stop and let this image stay with you, because it is part of the official evidentiary record of a federal investigation, and it is not something that should be easy to move past. Investigators photographed the recovered materials. Those photographs were entered into evidence and later released publicly. They show documents bearing classification markings spread across the floor of a storage room at Mar-a-Lago. Beside those documents, on the same floor, in the same frame, are framed magazine covers featuring Donald Trump, classified national defense information. On the floor of a storage room, next to framed magazine covers, that is the image that exists in the official federal record. Surveillance footage from inside Mar-a-Lago, subpoenaed by investigators, showed boxes being moved through the property during the period after the subpoena was issued and before the search warrant was executed. Trump's personal aide, Walter Nauta, was identified as having moved the boxes. The property manager, Carlos de Oliveira, AL alleged LY asked a Mar-a-Lago information technology employee whether the surveillance server footage could be deleted. Jack Smith charged Trump with 40 criminal counts, 32 counts of willfully retaining national defense information, 5 counts of obstruction of justice, 1 count of conspiracy to obstruct justice, 1 count of making false statements. The defense response: Trump had the inherent authority as a former president to declassify documents, including documents he had retained after leaving office. The storage conditions were appropriate given the security measures at Mar-a-Lago. The documents do not mean what they appear to mean. Judge Eileen Cannon dismissed the case in July of 2024, ruling that Jack Smith's appointment as special counsel violated the Appointments Clause of the Constitution and that his office had therefore been improperly funded. Smith appealed the dismissal to the 11th Circuit Court of Appeals. Trump won the presidential election in November. Smith withdrew the appeal, citing the same Department of Justice policy that had ended the election case. The dismissal stands. The case is closed. The photographs are still in the public record, and now E. Jean Carroll, because this is where the pattern finally produces its clearest, most definitive, most legally established result. Not a case that was dismissed. Not a case that was dropped. A jury verdict, rendered twice, upheld on appeal. Still standing. Carroll first publicly accused Trump of sexually assaulting her in an article published in New York Magazine in June of 2019. She described a chance encounter at the Bergdorf Goodman department store on Fifth Avenue in Manhattan sometime in the mid-1990s, and said that what began as a playful interaction in the accessories department became a sexual assault in a dressing room on an upper floor of the store. Trump responded immediately and publicly. He said Carroll was not his type. He said he had never met her. He said the allegation was a hoax designed to sell her book. He called her a liar on official White House communications channels while serving as the President of the United States. A photograph that Carroll's legal team introduced into evidence showed Carroll and Trump standing together at a social event in 1987, both smiling, in close proximity. He said he had never met her. The photograph is part of the official court record of a federal civil trial. Carroll filed suit. Legal obstacles, including arguments about presidential immunity and jurisdictional questions, delayed proceedings for years. New York's Adult Survivors Act, signed into law in 2022, created a one-year window during which survivors of sexual offenses could file civil claims regardless of when the alleged incident occurred and regardless of whether the statute of limitations had expired. Carroll refiled under that window. A 9-day civil trial took place in the spring of 2023. Trump did not attend. His legal team challenged Carroll's credibility at every turn, questioned the consistency of her account. emphasized the absence of physical evidence, and highlighted the decades-long gap between the alleged incident and the lawsuit. The defense argument, the allegation does not mean what it appears to mean. The jury deliberated for less than 3 hours. 2 hours and 50 minutes to hear all of the evidence, weigh all of the testimony, consider all of the legal arguments, and reach a unanimous verdict. They found Trump liable for sexual abuse and defamation. The damages totaled $5 million. $2 million in compensatory damages for the sexual abuse itself. $2.7 million in compensatory damages for defamation based on Trump's public statements after he left office. $280,000 in punitive damages. 2 days after that verdict was read in open court, Trump appeared on a live CNN town hall broadcast and called Carroll a liar again. He repeated the denial that the jury had just rejected. Carroll's attorneys captured those statements and amended their filings to incorporate them. A second trial focused entirely on the defamation claims arising from statements Trump made while serving as president in 2019 was held in January of 2024. Trump attended this trial. He was present in the courtroom. He left while Carroll's attorney stood before the jury and described in specific detail what the evidence showed had happened in that dressing room. The jury deliberated and returned with a verdict of $83.3 million, $65 million in punitive damages, $11 million for damage to Carroll's professional reputation, $7.3 million for emotional harm and other compensatory losses. In September of 2025, the United States Court of Appeals for the Second Circuit reviewed the $83.3 million verdict and upheld it in full. The 3-judge appellate panel wrote in their opinion that the degree of reprehensibility of Trump's conduct was remarkably high, perhaps unprecedented. They noted that the defamatory statements had continued for at least 5 years, that they had become more extreme and more frequent as the trial approached, and that Carroll had been subjected to a documented wave of harassment including death threats as a direct result. Carroll's $5 million verdict from the first trial was also affirmed on appeal in December of 2024. Both verdicts stand today. Trump continues to appeal. Now, we come back to the number we started with, 34. And now that you have seen the complete documented record, now that you have seen the checks bearing Trump's personal signature, the photographs of classified documents spread across a storage room floor beside framed magazine covers, the official transcript of a phone call requesting exactly one more vote than the certified margin of defeat, the financial statements listing a New York apartment at nearly 3 times its publicly recorded actual size, and the photograph that directly contradicted the claim of never having met the woman who sued him. Now you are ready to understand what that number truly means in context. On May 30th, 2024, a unanimous jury of 12 American citizens found Donald Trump guilty on all 34 felony counts of falsifying business records in the first degree. It was the first criminal conviction of a former president in the 248-year history of the United States. Sentencing was scheduled for July, then postponed to September because of the Supreme Court's immunity ruling, then postponed again at Trump's request until after the election. He won the election. On January 10, 2025, Judge Juan Merchan convened the sentencing hearing. He noted that the conviction was valid, that the jury's verdict was supported by the evidence, and that it represented a serious matter that deserved to be treated as such. He then sentenced Donald Trump to an unconditional discharge, no prison time, no fine, no probation, no supervised release, no consequence of any kind, because the law, as he interpreted it in the circumstances presented, left him no other option. 20 days later, Donald Trump placed his hand on a Bible and was sworn in as the 47th President of the United States. Stand back from all of the individual cases now and look at the complete picture at once. A unanimous jury convicted him on 34 felony counts. That conviction stands and is under appeal. A jury found him liable for sexually abusing Jean Carroll and defaming her, awarding $5 million. That verdict stands and is under appeal. A separate jury found him liable for defaming her again and ordered him to pay $83.3 million. That verdict stands and is under appeal. A federal judge ruled, before the trial even began, that the Trump Organization's financial statements were fraudulent. That finding stands. An appeals court affirmed it. The phone call to Georgia's Secretary of State is on audio, publicly available, and contains a specific request for exactly one more vote than the certified margin of defeat. And across every single one of these cases, the response to every document, every recording, every signature, and every number followed the same script for criminal indictments. 90 felony counts, 1 conviction resulting in no sentence, 3 cases closed without a jury ever hearing the evidence. Not because the evidence was found to be insufficient, but because of a Supreme Court immunity ruling, a prosecutorial disqualification arising from a personal relationship, and a constitutional policy that prohibits the criminal prosecution of a sitting president. Over 200 Department of Justice employees who worked on these investigations have departed the department, according to statements made by the Deputy Attorney General at a conference in March of 2026. The Carroll appeals continue. New York's Attorney General may appeal the decision that voided the financial penalty. The hush money conviction is being challenged in state appellate court. The legal story is not finished. But the part of it that was designed to produce accountability has, at least for now, produced none. This is the documented record, not opinion, not commentary, not the framing of any political side. What courts decided, what juries found after deliberating, what judges wrote in official rulings, what the official certified transcript of a recorded phone call contains, word for word. A man who was convicted of 34 felony crimes by a unanimous jury of his peers sits in the Oval Office. The conviction is real. The office is real. The evidence is real. All of those things are simultaneously true. And the question of what it means for every institution, every law, every norm that was supposed to make that impossible is one that no verdict, no appeal, and no future court ruling is going to answer on its own. That answer is going to have to come from somewhere else. If this video gave you something that the daily news cycle never does, hit the like button right now and make sure you are subscribed. We track every appeal, every new filing, every legal development in all of these cases in real time. And what is coming in the Carroll appeals and the New York fraud penalty fight over the next several months is something you are not going to want to miss. Drop a comment and tell me, out of everything you just heard, which single piece of evidence do you think is the hardest to explain away? And share this video with someone who believes all of these cases are already resolved. Because the official record shows they are nowhere close to finished.